If you can't trust their advice, then you're going to just wonder the whole time. And that is no way to go through a divorce, a modification, any family law proceeding, because the trust of your attorney is so important so that your future is what you want it to be. Welcome to Women Winning Divorce, the podcast helping successful women navigate divorce with dignity so you can protect yourself, your children, and your assets. I'm Heather Quick, founding attorney at Florida Women's Law Group, where women win at life. Welcome to this week's episode of Women Winning Divorce. I'm Heather Quick, owner and attorney at Florida Women's Law Group. Today, I am talking about whether or not it's time to break up with your attorney. And so I'm going to be doing this episode on my own and in response to many questions we've had recently and over the years. And so I'm hoping to provide some clarity over this difficult question and potentially give you some guidance if you are currently feeling this way about your current attorney. So first, let's talk about, what you should look for in an attorney. And I know you're thinking, well, I already know this isn't working, Heather. So why are you bringing this up? Well, I am, because for those of you who aren't in this situation, it may help you. And also, this may clarify for those of you who are concerned about the current relationship with your attorney. There may be some ways to tweak that and repair that relationship. So, of course, first, we're talking about your attorney representing you in your divorce or family law matter. Because that's obviously what we do and focus on. And that's where we see quite a bit of that movement from one attorney to the other. And I'm going to talk about some reasons why that may happen. Now, first of all, it may happen just due to scheduling conflicts or conflicts in priorities. You may hire this attorney, have met with them, and then upon taking your case, maybe they didn't disclose how busy they were, and they didn't recognize the amount of work or the type of case, as far as maybe it's more adversarial than they anticipated. And now they don't really have the bandwidth with which to continue to represent you. They may bring that to your attention, or you may notice it and say, listen, I think I deserve a little more attention here, a little more focus on my case. And that's when that may come up. But listen, I just don't have, maybe it's just a sole practitioner. They don't have support staff that can really help you move things along, or just too big of a caseload. So that certainly can happen. And, you really do want to ask that. So when we talk about the beginning, what to look for in an attorney, I think you need to ask your attorney, do they have the bandwidth, right? Do you have the capacity in your schedule to handle my case? And that's a great question, because otherwise you're not going to know. And then, you hire them and next week they're like, so sorry, I'm about to go into a 5-day trial, and then, mediations after that. So I really am not going to be able to meet with you for another 4 weeks. For some, you may be okay with that. You may be like, that's okay. I'm rightly not in a position to move quickly. I'm ready to go slow. But for a lot of people, that may not work. So you definitely want to ask that when you meet with your attorney. And you want to have questions, and you also want someone who listens to you when you're telling them what's important to you. And certainly they should ask you. If they don't ask you what's important to you, I suggest keep looking. If they don't ask you your goals, I would say keep looking. You need someone who is going to listen to that, because that is going to alter their approach. But also, it may be that the goals and the things that you want don't align with the way they practice. That is something that, if you can find out in the beginning, is really important to do. Let's talk about matching your communication style. Now, I'm going to tell you, this is tricky, because communication, as we know, varies from person to person. And typically when you are in litigation in a family law divorce matter, you're going to be in a heightened emotional state. Like, this is your life, this is your children, your money. These are a lot of things that can create more emotional responses from you than you may normally have, right? This is not, say, your typical way of operating, but it may happen in this time. And I think it's very important to ask, like, how are you going to communicate with me? Because if they say, for example, we will only be communicating with you by email. Our staff only emails because we want a record of everything. We will not be speaking on the phone. That may or may not work for you. I would suggest that, and then everything by phone. Well, I think always you should memorialize a conversation again to confirm that there is that proper communication, that you heard what you thought you heard, and they said what they meant to say. And that's very, very important. Anytime that we have an important discussion with a client on objectives and goals and plans of actions, we do memorialize that either in a case plan, updated case plan, or simply in an email, like, okay, this is what I heard you say, and based on that, I'm pretty sure we agreed to take, these next steps, ABC. And that's really good. And you want to do that, because if your attorney is going in one direction and that was not your understanding of the conversation, you may not know they're going in a different direction until thousands of dollars of fees have been spent and work has been done, and you really were not on board with that because maybe there was ineffective communication or you didn't understand. Now also, understanding that, and this is helpful in a case that is maybe ongoing, or it's where you're going to modify. And in those cases, you're already assigned a division. And so typically we will know who your judge is, and your ex may or may not already have an attorney. If that information is available, I think that's very important to discuss in that initial stage of consultation, because you're going to want to know, have you been in front of this judge? What do you know about this judge? Because it's not really to necessarily get favors in front of the judge, but you want to know how they rule and what their position may be on certain things. Because that will affect your case. So I believe that's really important. And if you are in the middle of an ongoing case, you want to make sure your attorney is well aware of things that are already on the court's calendar, because you're going to be required to show up, and it is not a guarantee that because you hire a new attorney, they're going to get things continued and moved on. And we'll talk a little bit more about that when switching attorneys, and that's a big consideration that you certainly need to think about, which is why, if you are listening to this and haven't hired an attorney, that's why it's so important in the beginning, because, obviously when you look back, you'll say, oh, there were these red flags. And it's very important to know that they have the availability, for you. So please, for our listeners, please go back and listen to episode 29 and 52. Both episodes are all about selecting the best divorce attorney for you. And, we talk about things that I hope you will find provide very good advice, tips, questions to ask, and things to pay attention to. If they're talking the whole time, that is probably an indication that they haven't listened to you, right? If they're the ones talking the entire time. So now let's talk about, when do you break up with your attorney? Because this is something that many times clients will come to us, potential clients, and say, well, I feel I'm in so deep with this attorney. What do I do? And that's a difficult question. So, I'm going to try to help you navigate if you're experiencing these things. And if you're not, it's great, because now you'll be ahead of the game, when you are looking for an attorney. But some common issues we see is the clients do say, it's been 6 months and nothing's been done. So they feel like there's really inactivity. No action is being taken. And sometimes that's true, but sometimes it's not the reality. Okay. And then that's poor communication, right? The attorney has not communicated to you what's going on. But, one of the things we'll do is look at the docket. As attorneys, within our circuits, we can pull up the docket. So I have been in a situation where I've said, well, I see you've got several court dates coming up. And maybe I didn't know that. And that's a problem too. Or I can look at it, we can say, yeah, nothing, you're right. Nothing is on the court file. Maybe they're trying to get through discovery, but that's the most problematic when you see the case has been filed and really no action in the past 6 months. Then there can be a lot of reasons for that. And sometimes as a client, you don't want to hear this, but maybe you have played a part in that. And so, which of course, as the next consulting attorney, they don't know that, but that can be if you're not providing information. And, oftentimes not every firm has the staff to really hound you for certain documents, or maybe it's, you might think of it nagging, but really we're trying to get your case done. And so if you haven't been responsive and you haven't provided the documents, that could be a reason there's no action. And I caution you in that case, because if you're gonna have the same behavior, switching attorneys is not going to do you any good. That's not necessarily an attorney problem. That is a communication problem, or maybe you're having a block on getting this stuff done. But that does come to the next one, which is lack of communication, which I did touch on in the beginning. Many times, and if you look at the statistics, the number one reason all clients complain, or not all clients, but when clients have complaints to the Florida bar, or probably any other bar, the number one is the lack of responsiveness with their attorney, or lack of communication. So clients maybe feel like they aren't receiving updates, or that their attorney's not responding. And, I'm not here to defend or attack. This is why I'm talking about this, because I really think it's important that you, as the client, you do need to advocate for yourself. And I would reach out, to your firm and find out why you haven't heard anything, because their philosophy may be, well, no news is good news, and I'll let you know when something happens. And that can leave you in a very stressful and sometimes anxious state, because you're like, well, what does that mean? Right. And what you don't know is that, all right, 45 to 60 days is how long it's going to take, if things are going well, to receive and exchange all of the discovery. So they are not, if you want to look at it from the good side, they're not looking to call you to say nothing's going on. But that's also, if you're sitting there wondering, those days seem much longer than they should be, and you're worried that maybe you're missing something, or your case is not moving accordingly. So again, you do need to ask. You may have said, don't call me unless there's something to say. So again, look at your, responses to them, and also, really look at, did they tell me they would not be calling me for 30 days because nothing's going on? I don't know that. That's a good thing for you to look at. And in cases where it's in the beginning, it's typically common that the clients want to, you want to give your attorney so much information, but there are litigious ones, and there may be, hey, the credit card got shut off, there's issues with the children. And you do have to let your attorney know, your paralegals, your team, and ask if there's anything they can do to help you. So that, is part of the communication. It does go both ways. But again, are you on the same page? That's the biggest thing. And what is a reasonable turnaround time for a response? I think that as a client, you have a right to ask that. And you have a right to say, okay, I understand, right? I'm not your only client, and you're going to be in a 5-day trial. You're going to be pretty much out of the loop. Well, who do I get to talk to when you're not there? That's really important because there could be an emergency. There could be something very important. Is there another attorney in the office that you can speak with? Is there a paralegal? What is that process? That's reasonable to ask. And again, that's why it's so important when there is support staff, because they'll let you know, listen, they're going to be in trial day or mediation, but I know I will be able to at some point get a message to them that you need to talk to them, or you need me to update them on an issue. So that's one thing. And usually, like in our office, if it's an emergency, certainly another attorney will get on the phone and address the issue. And you do want to know, like, what's the backup? Because, right, your attorney's going to go on vacation and things as well. So there's going to be times where they're not available. You do want to know the backup and what is a reasonable turnaround. Is it 24 hours? Is it 48 hours? I think both of those, depending on the issue, are reasonable. But you should ask that, and you should be okay with whatever that answer is. Like there are some attorneys that it's just them, right, in a laptop, and they have their cell phone, and so they'll talk to you all the time. But if they're sick or they're unavailable, nobody's talking to you. But that may be what that may be exactly the communication level you want. I would caution you, and I'd be careful, because you probably will be billed for all of those conversations. And when you can communicate that easily with your attorney and that often, you may not realize how quickly those fees are going up and accumulating. Now, right, and that's on the communication, which I touched on as far as when they're not available. Again, who is the most appropriate point of contact? Should you communicate with the paralegal, the legal assistant? Where's that line of communication? And I think it's just important. You want to be able to talk to somebody. In communication, one of the things that I have found over time in my experience is that a lot of times things can be lost in an email because there's no tone. And so depending on the mood you're in when you're reading it, you may take something to be a bit more harsh than it is, or maybe something that is more of a directive you take as a suggestion. So emails, just they're inherently leaving a lot out. And on certain issues, I think that it's very important that you have in person, or at least on the phone, Zoom, where you can see the body language, very important. And they can read yours to understand where you are. So again, communication, I would say, is extremely important. And one of the big reasons that clients feel the need to break up with their attorney. All right, let's talk about mediation. Often I have met with clients who are questioning whether or not to break up with their attorney. And they have come to our firm and said, we went to mediation and didn't settle. I felt like my previous attorney, didn't know what they were doing. I felt like they did not prepare me, and I had no idea going in. Well, that's an issue. That's an unfortunate issue. So if you're listening to this and never been in that situation, make sure you advocate for yourself with your attorney, that you have adequate preparation prior to mediation, and that you are well versed in what to expect during that mediation. And I'm not just talking about the format of the mediation. I'm talking about the issues. Know your best and worst day. Be prepared to settle, because that will allow you to make the most of mediation. And a question people ask, right? Because they're like, well, I didn't know they didn't know much about mediation, or they weren't going to be prepared. That's a question you need to ask. Your attorney may have a different philosophy. Our philosophy is to be very prepared for mediation, ready to settle. I don't think that, at mediation, you say, well, if we don't settle now, I'm going to go hire all these experts. Sometimes that may be necessary, but as far as it's not really a strategy. It's like a tactic. And if you think it's going to scare them, it's not. I don't think that really causes anybody in wanting to settle. I've certainly heard that. And I said, well, you should have done that before, because you have no information here to really persuade us to compromise one way or another. That's the way we prepare for mediation, so that we're ready with your best case, and we're able to really show them like, oh, no, we're advocating for this and we think we're going to win. And of course, a good mediator will share with them the information you find appropriate. For example, business valuations, that's, those are numbers. You have this evidence. Now they may disagree, but they're going to have to go hire their own expert to counter that. So if you are going to mediation without those details, you are now probably going to take another year. And for our listeners, I want you to know, because this happens more often than you would think, you may be forced to mediate again. Now, you come to us, you didn't have a great mediation, you do hire a new attorney, and we employ some strategies, and we may recommend, I think we should mediate again, because at the end of the day, if you are able to come to an agreement through mediation, the studies show you are going to be happier overall long term with your agreement because you had more of a part in it. Now, there are situations where you're quite happy with your agreement after trial. So I'm not trying to say that never happens, but I am sharing those statistics with you so that you know it is often in your best interest to settle if you can. If your ex-spouse is unreasonable and doesn't care, there's no settling. That is beyond your control. But if there's just a few compromises you may have to make, obviously rely on your attorney, also go with your gut, but you want to, leave mediation, obviously with a good settlement. And, sometimes people ask, well, I got this settlement offer in mediation and, can I get your opinion on it? So if you've signed it, that is a contract and you're bound by it. So that will be a waste of your time asking the attorney unless you just want to know. But if you have like proposals and you are discussing that, you just need to be very careful. There are a lot of confidentiality rules in mediation. And, if, we do have attorney-client privilege, and it is privileged communication, even during a consultation. But, if you want a second opinion or you want to know, well, was this good advice? Or they said we couldn't settle this issue, so I had to go to court still on, one issue, but we settled part of them. That is just very fact dependent on your facts, but it does happen. And, as a general rule, I would say no. You want to settle it all or just go to trial, right? Because the court has more things to decide upon. There's more issues. But in some cases, it might be worthwhile to partially settle some of the issues that that are there, and it narrows what needs to be contested and argued. So those are a lot of the issues that we have commonly seen when women come to our office and say, I'm thinking of breaking up with my attorney. And, a big question they want to know is it going to be different? What I can tell you is obviously it is going to be different from a standpoint of we are a different firm and we probably do things different, but your husband still has the same attorney he has, you still have the same judge, and we can't really promise miracles. There may be reasons that the case got delayed that are due to the judge, which is very disheartening to hear, I know, but it has been our experience. And so that's why if you really are feeling that, you certainly want to investigate in a consultation, and you do want to ask some of the questions I've talked about, and particularly the reasons you're unhappy. Discuss those with the next attorney, because I will tell you, as attorneys, the second or third one in line, we are going to be apprehensive about taking your case, and we may not want your case. And that may have to do with the position you're in and maybe your particular behavior that would be evident in the court record, as far as if you haven't been following with things, haven't been disclosing information, then, we read between the lines and we think, well, maybe you are making it more difficult and you're blaming your former attorney. And so then you just wanted to get us on board. Again, that's a red flag. And I share that with you because if you are looking, you want to understand what are the attorneys looking at. We're also going to look at, hey, do you owe your other old attorney money? And that's why you're leaving. That's a problem as well. We usually won't take cases where you're in debt to another attorney because you're probably going to be in debt to us, and maybe you don't value paying your attorney's fees, and that's a problem. Even if you haven't gotten to the full realization or the final end of your case, it takes time many times, and if you're coming to us at a negative or where we have a lot more work to do, it's going to be more of an investment in time and fees in order to get up to speed and really strategize on how to hopefully switch the momentum for you. So those are things certainly to think about. But if you've come through all that and you're like, I do need to make a change. There is a bit of starting over. You do need to interview other attorneys. And I would disclose as much as you possibly can in order to start that relationship off on the right foot. And then, typically it's probably going to be a higher retainer than your initial retainer with an attorney was, because now there are pleadings we have to review. We are going to have to communicate with your former attorney to get any documents that are outstanding. And that's why I say pay your attorney, because if you haven't paid them, they don't have to send us the documents. And that may be more work for you, more work for us. Again, think about that and talk to, the attorney you're consulting with. And, we're going to have to get up to speed. Well, that means we need to really look at all the pleadings, talk to opposing counsel, and maybe, talk to your former attorney. That can take a bit of time. And also know that if you've got an upcoming date on the calendar, you need to be 100% sure that new firm can show up on that date. Generally, if we don't think we can show up, we will not take a consultation because we don't want to waste your time. And we know, like, looking at the calendar, we don't have anyone available, and we can't assume the judge is going to continue. Unfortunately, the multiple changing in attorneys can have a negative connotation. We do our best to turn that around for clients if we think that's what's going on, but we are mindful of that. And I think that makes sense to you. And you might be in a situation where you're like, yeah, my ex is on his third or fourth attorney and it keeps delaying things. And that is the reality. So you have to balance that a little bit in knowing, hey, is the court going to take that out on you when you ask for more time? So again, if there are things upcoming, you definitely want to make sure any new attorney you meet with understands that. And then, it's not like you've got to go have the breakup or you've got to write the letter. The attorney, we will do that for you. We will advise your current attorney that you have hired us, and you'll sign something just that says you consent. And that's what we have to do and move it in as far as the court is concerned. So your old attorney is on the hook until the judge signs the new order for a new attorney. That can be very confusing to people because you're like, well, I told them I'm done. Now, typically, they should not do any work, but if it's necessary, we have to, as members of the Florida Bar, ethically, if things are required and if we didn't do it, it would harm you, we do have to still do it. So that's why if you're thinking about it, don't drag your feet with that. You need to find a new attorney, at least interview some so that your case doesn't stall too much. And, generally breaking up with your attorney happens like any other relationship. The trust and confidence in them has been broken and for a myriad of reasons, but they could be negotiating a great settlement for you. And if you were to have someone else look at it, they would say, hey, that looks really great in light of your facts and circumstances and financials. But if you have lost your trust in that attorney, you're not going to believe it. And that's why it is very important to really, make sure that that relationship is intact and that they understand when they have your trust, but also if they've broken it, can you get that can you get beyond that so that you can trust their advice? Because if you can't trust their advice, then you're going to just wonder the whole time. And that is no way to go through a divorce, a modification, any family law proceeding, because the trust of your attorney is so important so that your future, is what you want it to be. So, this is a topic that just happens, periodically, and I wanted to address it because I think that often the majority of women that reach out to us, they just don't know what to do, and they don't know maybe the best way to assess it and how to move forward. And what you may find as you may go consult another attorney is that, wow, your case has gone along fine, and we don't see anything that seems to indicate they're not working in your favor. So then it goes back to the communication, and there may be an opportunity to repair that, but I would certainly address it, because if your case is still ongoing, you really want to know that your attorney's got your back, and you want to be able to trust their advice. And you want to be able to know you can reach out to them when something's come up and you have a question, and that they are going to do their best to answer that for you. So I hope that this episode has been helpful today in giving you some information on a topic that may not be anybody's favorite, but it's the reality of what happens. And again, if you can go back and listen to episode 29 and 52 on how to choose the right attorney in the first place, that would be a great episode before, even if you're going out now, you have an attorney you want to break up, listen to those. So at least if you are going to make a change, maybe you're going to ask some different questions this time. I thank you all for listening today. And listeners, if you or someone you know is going through a divorce or is thinking about a divorce in the Northeast Florida area, please reach out to us at floridawomensLawGroup.com or join our Facebook community, Women Winning Divorce. You'll find the links in the episode description. And if you enjoyed the show, we would truly appreciate any comments you have on future topics. And if you leave us a 5-star review, that will allow other women going through similar challenges to find this content. Again, thank you so much for listening.